Hey, it's Vanessa Hardy from Long & Foster. I want to give a little bit of time today to a topic that comes up so often and can blow up a transaction so often that I find settlement attorneys will come to our realtors' offices at least once a year and talk about this topic, and that is who signs the documents. So I want to talk a little bit about powers of attorney, LLCs, trusts, and then estates. So power of attorney, you see this often, it's very common, but it can cause problems at the end of a transaction if you don't catch this early. So if you've got a married couple, let's say, this happens so often in our area because a lot of people travel overseas working with the government. If you've got a married couple, husband works here in the area, but the wife could, like, in a moment's notice, jump on a plane and have to go to Africa, and they're selling their home. This happens very often. So the husband is saying, hey, no problem, I've got a power of attorney in the drawer in the kitchen. I can dust that power of attorney off and I'll be able to sign for my wife while she's out of the country and she doesn't have access to email, that kind of thing. No, that can work a little bit, but not through the whole transaction. So here's what you need to know in advance. The best way to handle this, if you know you're selling a property with someone who might be out of the country and not be able to sign something before closing, and most in particular at closing, if you know that, the best thing to do is go to a settlement attorney right when you're putting the house on the market for sale. Go to a settlement attorney and ask them to give you a specific power of attorney, because you may have a power of attorney in the kitchen drawer that you often use because you've got a spouse that's in and out, that leaves the country on a moment's notice. And maybe that general power of attorney, maybe that works for what you've used it for, but you cannot use that to actually sign a deed. And you probably shouldn't use it even to sign the listing agreement and the sales contract. Let me explain why. Scammers, that's one thing. Scammers are looking to get involved in your real estate transaction and steal money. So settlement companies, more and more and more, are very careful. They want to know that the person signing the deed is the right person, so that there isn't any scamming, anything illegal taking place. So the settlement company is going to want to know when you're signing the deed, they will want to have done a title search. They want to know exactly who owns the property, what capacity they own the property in, and they want to know who exactly should be signing the deed. Their preference would be for that person to actually sign the document. So their preference is to not use a power of attorney for the actual deed. So I'll back up a little bit. Here's the thing. You don't want to be in a situation where 4 days before closing, you're calling the settlement attorney and saying, my wife's in Africa, she can't sign, I'd like to sign for my wife, so, just use this power of attorney I have in the drawer. That won't work. Or, hey, just come up with some documents really quick, put together a power of attorney really quick, and I'll just sign for my wife. That won't work either. So they need to do a title search, so that takes time. So they can't just throw the documents together based on your phone call. They need to do a title search. So once they do the title search, here's the thing. They would like to have your wife sign not only the specific power of attorney, specifically giving you the right to sign for your wife, they need your wife to sign that document, and typically what they're going to do is say, hey, while she's signing the power of attorney, let's just have her sign the deed as well. She's going to have to sign those in front of a notary. So if you're out of the country, if you're someplace like Africa, you're going to need to go down to the U.S. Embassy to sign it. It can just be a nightmare. So let me back up. If you're putting your property on the market and you know you've got a spouse that could have to jump up and leave the country on a moment's notice, you want to do all of that in advance. Let your listing agent know that you've got that kind of a lifestyle where someone could be gone at any minute and it would just be hard to reach them. You want to make sure you get all those documents signed in advance. Because here's the wrinkle. Often you see people signing the power of attorney, sign listing agreement and sales contract using a power of attorney. Nobody really asks questions. You're not going to have a buyer ask to see that seller's power of attorney. Everyone just assumes that they've got the right to act as a power of attorney. The settlement company will not make those assumptions, but I've certainly seen buyer's agents, listing agents assume that the power of attorney documents are there to support who's signing the sales contract. But imagine the seller is using a general power of attorney that they pulled out of their kitchen drawer that was valid, but they pulled it out of their kitchen drawer to sign the sales contract as an attorney in fact. But then we're getting ready to close. We're 2 days outside of closing and the buyer gets cold feet. They don't have any loopholes, no contingencies to get out of this contract, but they've got cold feet. And let me tell you, that happens. Anybody who has sold real estate in this area for more than 5 years has seen that happen. And I've been selling for more than 20 years. So I've seen it happen a lot. Buyers get cold feet sometimes. So if you've got a buyer who gets cold feet and they pick up their sales contract and take it to an attorney and say, I don't want to buy this house, do I have any loopholes? You don't want to get stuck as a seller having used a power of attorney that perhaps a lawyer could say, well, we're gonna see if we can declare this contract void because we don't think that power of attorney actually gave that husband the right to sign for that wife. You don't want to see your contract blown up because you don't have the right documents to sign. So the best thing to do, if you think you might be in a situation where one of your sellers may not be around when it's time to sign the sales contract, work in advance with a settlement attorney. Any good real estate agent in our area has a relationship with a settlement attorney that they can call and assets. It will cost money. You need to have the settlement attorney do a whole title search and do a real specific power of attorney. That is a document you can use and you can stand on to sign everything you need for your wife while she's in Africa handling business. So I'd be happy to be a resource if you need help. Always feel free to contact me because I'm always helping buyers and sellers to navigate complex transactions just like this. Okay, so we were talking about signing with a power of attorney. I want to talk about signing with an LLC because we see this all the time. I would imagine across the country, but definitely DC, Maryland, and Virginia, you see buyers and sellers signing documents where an LLC is the buyer or an LLC is the seller. So here's the main thing you need to know. In any situation, the person who owns the property, the person who's selling the property, it's a person. So in legal jargon, we have this way of speaking of corporations, LLC, trust. Those are legally people. So a person has to sell or buy, and the LLC is a person in a legal sense. You remember when Mitt Romney said corporations are people too, and everyone ate him up over that. But when we're talking about signing documents, corporations are people too. So a corporation, an LLC, a trust, they are people, and those people assign humans to sign documents for them. So in an LLC, you're going to have a managing member. The LLC is a person, and that person assigns usually a managing member to sign documents on their behalf. So if you are a seller and you're going to be selling a property as an LLC, the settlement company is going to want to see a number of documents from you. And the best thing to do if you're buying or selling as an LLC is get all these documents together in advance so you're not scrambling at the last minute. They're going to want to see articles of organization, maybe your membership agreement. They'll likely want to know that that LLC is active in whatever state it's organized in, so that they know the LLC actually has the right to buy and sell and own property, all that good stuff. So when it actually comes time to sign documents, the settlement company will want to know that the person signing on behalf of the LLC, that legal person, they want to know that the member, the managing member that's signing, actually has the right to do so, and there are going to be documents that you can give to the settlement company, probably articles of organization, documents that set forth these are the people that the LLC has decided have the right to sign on my behalf. It is so important that if you think a managing member might not be available to sign documents at closing, you must talk to your settlement attorney in advance. Gather up all of those documents, talk to your settlement attorney well in advance, because in some cases, only that managing member can sign documents. They won't be able to appoint someone else to sign for them. It all depends on the specific LLC, but if you think that person, that managing member, isn't available, you need to make sure to get with your settlement company in advance. And here's the thing, it works the same way with a power of attorney. If the LLC is signing documents, and let's say there is a managing member signing documents for the LLC, and they've signed the listing agreement, they've signed the sales contract, and then it's time to close. What if you haven't been signing correctly? What if the right people haven't been signing for the LLC? This is very important. You want to talk to a settlement attorney before you're ratifying if you have any question about who is actually signing your documents. Because if you're a seller and you're signing it as an LLC, and let's say you've got a wife who is the managing member, but the wife, for whatever reason, can't sign the sales contract, so she has her husband sign for her. If that husband doesn't have the right to act as the LLC, and then you're on your way to closing and you have a buyer who has cold feet, you don't want to have a contract that someone could say, well, this contract's not really valid because the right person hasn't signed as the seller. The seller is an LLC. The law says that that LLC is a person, and that LLC has to appoint someone to sign on the LLC's behalf, and it has to be the right person that signs the documents. So you really just want to be very careful. If you have any questions, your real estate agent should have a relationship with the settlement company, and you can call and talk to the attorney and make sure you've got the right people signing for your LLC. Very important, because you want to get to closing with a contract that is very solid and that your buyer can't blow up at the end if they should get cold feet. All right, so another entity that we see often in DC, Maryland, and Virginia, a buyer or seller that is buying or selling as a trust. So again, the trust is a legal person, and the legal person is going to appoint someone to sign on its behalf. And so you want to look at the trust documents. The trust documents will say, I, the trust as a legal person, I'm appointing this trustee to sign documents on my behalf. This is important because you absolutely have to have your trust documents. If you own a property in a trust, make sure that you know where those documents are. Because the settlement attorney, well before your closing date, the settlement attorney is going to want to see a copy of those trust documents so that they know that the person showing up at closing has the right to actually sign documents for that trust. And again, you want to be careful. If you've got a situation where a husband and a wife own the property and they own it in a trust, and they are, husband and wife are appointed to be trustees to sign for the trust. And if the wife is going to be in Africa at closing, if you are selling a property and you have any idea that maybe one of you might not be around, might not be available at closing, you want to talk to your settlement company well in advance of closing, because it may be that the husband isn't allowed to sign for the wife. Everything is dependent on, well, what does the trust document actually say? So you want to make sure you have that document available and that you can get it to the settlement company. I had a situation years ago where I had a seller, great guy. He had a lot of money. He was older. He married a woman who was much younger, and his kids did not like that. And he owned a property in trust, and he needed to give the trust documents to the settlement company, and he didn't have them. His kids had them, and the kids were not interested in helping him to sell this property and have all this money go to him and the younger woman. It really was kind of crazy. He was finally able to track down a copy of his trust documents. But had he not been able to get a copy, I mean, it just could have been a real nightmare. So you want to make sure, if you own a property in trust, hold on to those documents. If they were drafted by a lawyer years and years and years ago and you can't find that lawyer, you may be the only one that has a copy. So if you own a property in trust, do yourself a favor, print those documents off and put them in a safety deposit box, a fire safe box, put a copy up on the cloud so that when you actually need those documents, they're available to you. But again, what you always want to do in a situation like this, where you own a property in trust, where you own the property as an LLC, or if you have a situation where someone you think might not be around when it comes time to close, make sure you talk to your settlement attorney in advance. Because again, if you own the property as a trust and you're signing the sales contract and the right person doesn't sign, odds are nobody knows about it. And if everyone is interested in buying and selling and it all goes through to closing, no problem. But if you run into a situation where you're selling a property and the wrong person signs, and then you've got a buyer close to closing and the buyer doesn't want to close, you've opened yourself up to potentially having a voidable contract, which is bad. So make sure you just get in touch with your settlement attorney in advance, talk to your listing agent, make sure everyone's aware of exactly what documents you're going to need to close and what documents the settlement company needs to let you know about in advance. Last legal person that I want to talk about is an estate. We see this a lot in Arlington and DC because we have some really, really old properties in this area, and you could easily have someone who's owned a property for 70 years and they're just now selling the property, and perhaps that property is being sold as an estate. This is big. So if someone has passed away, as I mentioned earlier, a person has to own the property. And if the person owned the property and then that person has passed away, nobody is available to legally act as the person who owns that property until the court has appointed a personal representative. So again, the LLC is a legal person and the managing member acts on that person's behalf. The trust is a legal person and the trustee acts on that person's behalf. The estate steps in to be the legal person. The other owner has passed away. The legal person is now the estate, and the personal representative acts on behalf of that legal person, the estate. So here's the thing, if someone passes away and they've got two kids, and we all know, we can look at the will, we all know that that person passed away and left everything to their two kids. The two kids are to split the estate equally. Those two kids can't just say, okay, let's go sell the house, we'll sign, we're the heirs, and then we're gonna split the proceeds. That's not how it works. The court has to appoint a personal representative. And until the court does that, there is nobody who can act as the person in place of the person who's passed away. There is no legal person until the estate goes through the probate process and the court says, okay, now there's a legal person, there is an estate, and here is the person that everyone can recognize. There's an estate and there's a personal representative, and that personal representative is going to be the legs and feet, the hands and feet of the estate. That's the personal representative. So that person has the right to go out and do everything the estate can do, selling the property, listing the property, signing documents at closing. The settlement company there are several things the settlement company is going to need, and I always keep a list, and I'm happy to share it with you. I'm going to have links below, a list of everything you're going to need in order to actually sell that estate property. So you're going to have to get a tax ID number for that legal person, the estate, tax ID number. You're going to need to set up a bank account for the estate, because settlement companies will only send funds. Once you sell, you've got $500,000 cash coming to you. The settlement company is not going to send that money off to the kids, because the settlement company knows, oh yeah, the guy, he left all his money to his kids, we'll just send the money there. No, the settlement company is going to send the funds to an account that has the estate's name on it. So you've got to get the personal representative has to get a tax ID number for the estate. The personal representative has to get a bank account set up in the name of the estate. And the bank will deal with that human, because you have letters of administration, which is just a fancy word for, here's my court document stamped by the court that says I, the human, have the right to act for the estate. So you can take that down to the bank. You can take it to the bank and they will let you open an account for the estate. The title company will let you sign documents for the estate. You want to make sure that you keep all those documents, because you're going to need that. You're going to need your letters of administration, the tax ID number, the bank account. You're going to need a certified copy of the death certificate. You'll probably be showing those things a lot through the process. But the key thing is, until you have a personal representative, there's just nothing that can be done with that property legally until that happens. So if you have someone who passes away in the middle of a transaction, I mean, unfortunately, it's tragic, but that happens. That everyone has signed the sales contract, everyone's on their way to closing, and someone passes away, that does not kill your contract. But it does mean that if it was a seller who passed away, and if we're not talking about joint tenants, we're not talking about rights of survivorship, if that person owned that property all by themselves, let's say, and they pass away, that doesn't kill the contract. If everyone still wants to go forward, if you've got a buyer who still wants to buy and the seller has passed away, then the heirs need to go on ahead and open an estate, get a personal representative appointed, and then go ahead to closing. I mean, it can take some time, but I've certainly seen cases where the buyer is like, hey, I love the house, I still want it. So let's all just make it happen. It takes time, but it's not that unusual, unfortunately. It's not that unusual that people pass away in the middle of a transaction. The main thing that I see people get tripped up on is you have to get that estate opened. You have to have a real person, and that is the personal representative, before anything else can happen. So as I said, I'm going to put some links in below for what you need to do if you're in this situation where you've got to get a personal representative appointed, what you need to do if you're trying to sell an estate, because there's a lot involved. I'm happy to help people navigate this, because I help buyers and sellers all the time with complex transactions. So I'll put a link below specifically if you need help with estates and selling a property that's owned by an estate, and exactly what steps you need to go through. Please feel free to give me a call if you need help. I'm Vanessa Hardy with Long & Foster, and I work with stuff like this all the time. I'm happy to be a resource.